They immediately notified the arbitrator that he was wrong and he didn't follow the hearing procedure. He made a decision in October. They didn't say a peep to anybody until February, 4 months later. And they got this bill a year and a half prior. They didn't say a peep when they got the bill. That they knew he wasn't following their procedure because they were double playing it. It's like I said in the first part. If he had ruled in favor of the district would have argued, no, he's an arbitrator. Look, this says matter of the American arbitrator, matter of the arbitration of Joseph Del Grande. How could you argue that he's not an arbitrator? No rational, reasonable person's mind could argue that he's not an arbitrator. But they lost, so that's what they did. Let's see what else we got. Oh, the fact that the board conducted itself properly, procedurally, and substantially is easily known and knowable. The court decision fully and finally affirming the board's determination is publicly available. That's a corrupt joke, which is a complete lie. They did not conduct themselves properly and procedurally. They lied and cheated and lied. They committed perjury and fraud under the penalty of perjury. Here's Mary Lou Comroe, an attorney admitted to practice law in the courts of New York State, hereby affirms that the penalty of perjury the following to be true. That's her affirming under the penalty of perjury the following to be true. And what does she do? She points to a page here in the record. Del Grande, however, did not turn over his medical. That's a lie. That was already proven. I gave him 3 signed medical release documents that gave him access to all my medical records. One lie on top of another. They established one lie in order to establish a second lie, to facilitate a second lie. Dr. Silverman's addendum demonstrates that those records were pertinent because the records show that Del Grande's herniation resolved. They should point to a page number 1092, 1095 in the record. Okay? That's a lie. This is the report right here. This is page 1092. This is where he falsifies medical evidence. As you can see it right there. He puts the top part of my doctor's report, who was primarily examining my neck, as Edelman clearly stated in the arbitration, which said I had full strength of my arms and legs, and this, I had full strength of my arms and legs the whole time through this whole injury. My injury was in my lower back. These morons. Every other doctor that examined me always said I had full strength in my arms and my legs. That shows the corrupt, deceptive nature of Dr. Silverman's motives. Then he only put 1 or 2 sentences in there, and then right here he puts these fraudulent statements in saying I'd be able to do a whole bunch of activities and blah blah blah. That's not in the doctor's report. He took words out of the doctor's report that said the actual doctor's report that he's trying to falsify. The doctor's report says, impressions, the patient's been followed for a back pain and a work-related injury. He does have some neck pain as well. There's a bit of numbness in his right thigh occasionally. Mildly decreased cervical and lumbar range. Impressions, neck and low back pain chronic. Activity modifications and precautions were discussed. I formally request authorization for cervical physical therapy. I do not feel this patient is a candidate for spinal surgery. Follow up again with myself as needed. He is told to call for any problems. This is what the doctor's report actually says that he falsified. Impressions, neck and low back pain chronic. It doesn't say anything about me being able to do a whole range of activities. Silverman falsified it and put his wording in place of all of the other words that are reported that I just showed you. And the best part about it is it contradicts Silverman's own report. Silverman's own exam of me, he had his hands on me and examined me, was only a few weeks prior to the date of this report. The date of this report is 12/15/08. It says 12/15/08. He's referring to Dr. Perkins' report. The report that he falsified and fabricated. This is his report, okay? See the date? 11/24/08. 11/24/08. Here's what he says. I think the anatomy at this point has not changed based on the information that we have. He still appears to have limitations based on the herniation at L3 and L4, which was related to the incident of 12/7/05. Okay, so he's saying I'm still permanently disabled almost 3 years after my injury. Regardless of the information contained in the medical record, this is clearly a surgical collectible lesion, and with appropriate surgical consultation would not require a major intervention to do so. I think excuse me. I think correction at the L3, L4 is clearly related to the 12/7/05 incident. This is Dr. Silverman's report, okay? This is the last medical evidence, if you want to call his report medical evidence, which apparently the district has the right to, then he's disqualifying himself. Because he's either saying he's not qualified to evaluate a firefighter based on his hands-on exam, because he's saying I'm still permanently disabled. Then a few weeks later, he makes an addendum and says I magically, my injury resolved itself. That's not physically or physiologically or rationally possible. This is how corrupt this whole case is based, solely focusing on this evidence right here. Falsifying medical evidence against his own findings. He found me to be permanently disabled. I don't even need to go out and show all the other workers' comp doctors who found me to be permanently disabled. He found me to be permanently disabled. But when that didn't work, Conroe goes out to Edelman, to Silverman, and says, Silverman, we got to put in an addendum, and I want you to falsify and fabricate and attach, use the first sentence of Delgram's doctor's report, and then strip the rest of the report out and put your own words in there so you can deceive the court. This is Silverman's words, making it appear that it was spoken by my own doctor. The examination doesn't sound very dramatic, and he appears to be quite functional. Symptomatically, he was reporting a little bit of numbness to the right thigh occasionally, but some numbness and some numbness of the hand, but otherwise denying any pain, numbness, tingling, or any weakness in the arms and legs. Functionally, he sounds pretty good. He sounds like he would be able to do a wide range of activities. How does this moron go from saying I'm permanently disabled in his report a few weeks prior to saying this without any medical evidence at all? Falsifying, tampering with medical evidence, stripping medical evidence out of the record to deceive the court. And as I said before, this is what he said at the bottom. Him and Conroe. What does it say? I warned Silverman, MD, being a physician duly licensed to practice the state of New York, pursuant to CPRL 2016, hereby affirm to you under the penalty of perjury that the statements contained herein are true and accurate. Okay? That's perjury. When you make a claim like that in a legal proceeding and you know it's not true, those are the two main criteria to making it perjury. Okay? Perjury is the intentional act of swearing a false oath or falsifying an affirmation to tell the truth, whether spoken or in writing, concerning matters material to an official proceeding. Criminality culpability only attaches at the instant the declarant falsely asserts the truth of the statements made or to be made, which are material to the outcome of the proceeding. Okay, that's the first criteria, which the district and Silverman repeatedly met under the penalty of perjury. The second criteria is that they knew when they were making these claims in a legal proceeding, they knew that they weren't true. They knew that they were making false claims to deceive the court to rule in their favor.